All right, good morning, everyone, and welcome. We're excited to have you with us today. My name is Julie. I'm the Marketing Communications Specialist here at Church and Casualty, and we're excited to do our HR and Employment Law workshop. So you've probably noticed that we're in a little bit different setup than we usually are. So we're actually coming at you live from a professional recording studio. So shout out to our friends at Sunset 17 Studios for our setup today. So while everybody is signing on, I will go ahead and introduce our guest speakers today. So we have Eric Becker. Eric is a senior partner at Cummins & White and an employment law attorney. And then we have Carla Oddie, who is a human resources professional and co-founder and principal of Mesa Network. So both Carla and Eric are part of our CCIA advisory team. So they specialize in nonprofits and houses of worship, and they help our customers with information, guidance, and education on HR and employment law related topics. So we're super grateful to have them part of our team as a trusted resource to our customers. So a couple items before we begin. First, we will be recording today's session, so it will be sent directly to your inbox. And then secondly, we have a Q&A portion of the presentation at the very end, so be sure to stick around for that. And if you have any questions, be sure to submit them at the Q&A box at the bottom of your screen, and we will do our very best to get to as many questions as we can with the time allotted today. So I will go ahead and hand it over to Eric.
Good morning, everybody, and thank you for attending the webinar today. Carla and I are going to be focusing on the new laws that affect California employers, including nonprofit employers and religious organizations, coming into effect here in 2023. Before I get started, I do want to have a quick disclaimer for everybody. What we're doing today is really trying to provide you some practical guidance on these new laws and what your organization needs to do to be in compliance. Nothing that we say here today should be considered as providing any type of legal advice because when it comes to issues that involve legal questions, every situation's different. And you want to make sure that all the facts that could change the opinion or the advice that you're getting are shared with your legal counsel before you rely on that advice. So just keep in mind today that we're going through this fairly rapidly. If there's any questions down the road about a particular situation, you can always utilize the resource that is provided by Church and Casualty to talk to either Carla and I or email us and have those questions answered. So, what are we going to be covering today? I'm going to be starting by talking about a couple of the major new laws that are impacting employers in California, starting with the pay transparency law, which is SB 1162. A lot of you may have heard about this. You might already be taking steps to comply. I'm going to be talking about the two main elements of this new law, which is the requirement that certain employers now post the pay scales for positions on job postings, as well as provide information on pay scales upon request from applicants and employees. I'm also going to be touching very briefly on some of the reporting requirements for larger employers. These apply to employers with more than 100 employees, which probably doesn't affect many of you that are attending this webinar, but it's important to understand what those requirements are if, for whatever reason, you get towards that threshold sometime this year. I'm also going to be talking about some of the changes to the Cal-OSHA COVID standards. In years past, the last couple of years, I probably would have spent an entire webinar talking about this. Luckily, we're now at a stage where there's just some minor adjustments that you need to be aware of in terms of the rules and protocols you have in place for prevention of COVID in the workplace. And then I'm going to be talking about a really important decision that came out towards the end of last year from the California Court of Appeal that talks about time rounding. And it's important for your payroll practices if you have any type of rounding that you are utilizing, and I'll describe what I mean by rounding, that you take a very close look at that, because it's likely that rounding is going to be found to be illegal in California in the near future. We'll also be touching on minimum wages, and then Carla is going to be talking about leave rights to care for, quote, designated persons. These are changes to both the California Family Rights Act, which applies to employers of more than 5 people, as well as the California Paid Sick Leave Act. So she's going to be talking about what is a designated person and what do your policies need to reflect in terms of these new requirements. Carla's also going to be talking about the new mandate for bereavement leave, unpaid bereavement leave in California. We're going to be touching a little bit on a law that was passed but is not going into effect until January 2024, which is a law prohibiting employers from testing or banning off-duty cannabis use. And we want to cover it briefly because towards the end of this year, employers are going to have to start thinking about it. But we have some good news on that front as well. And then Carla's going to be talking about some of the important issues that you need to be aware of that face religious employers. And then, as Julie said, at the end, we are going to have time for questions and answers, either on the topics that we covered today or just in general employment and human resources issues that maybe you have questions about or you're facing in your organization. So, with that overview, let's talk about the Pay Transparency Law, SB 1162, to start out. So, this law expands employee rights to pay information. And prior to January 1st of 2023, there was a law in effect that said employers had to provide pay scales to applicants, people who are applying for a job, only after they requested it and only after they interviewed with that employer for that job. So there was some requirement on pay transparency that was already in effect, but as you can see, it's pretty limited. And the legislature, and also, by the way, large employers had to provide EEO-1 reports. So again, employers that had more than 100 employees had to file a federal report, it's called an EEO-1, that set forth data about the race and ethnicity and gender of their employees and some data on their pay. So there was some pay transparency requirements already in place, but the California legislature said, you know what, we really want to make sure that employers are protecting the equal pay rights of employees. We want to make sure that people are not being paid unfairly or unequally based on things like gender and race and ethnicity, and therefore we are going to pass some additional rules that require this pay transparency. So the first and most important change that SB 1162 put into effect is that employers that have more than 15 employees now have to put pay information on their job postings. So if you do not have 15 employees, and that's 15 W-2 employees, and that would count both part-time and full-time, by the way. If you don't have more than 15, this doesn't apply to you. However, if you do have more than 15, you must include the, quote, pay scale on any job posting. So if you're putting it out on Indeed or Glassdoor or one of the online platforms, if you're posting it internally, if you're advertising for a position in any way, you need to include that pay scale somewhere on the job posting. If you use a third party for recruiting purposes, you outsource your recruiting to someone else, and they are the entity that is putting that posting online, on Indeed or whatever, you have to make sure that that third party is also putting the pay scale on the posting. You as the employer are liable to make sure that the third party is doing what they are supposed to do. Now, what does pay scale mean? This is one of the $24,000 questions, or $24 million questions, I'm not sure what it is now, that is left kind of open by this law. Pay scale is defined under the law as what an employer would reasonably expect to pay for the position. So what does that mean? My interpretation is it is not based on what the scale is for the employees that you currently have in that position, because you may have outliers or unicorns. Well, let me just give you one example. You may have a situation where you've got somebody in a job classification, widget maker, and they previously worked in a lead or supervisory position, and for whatever reason, they went back down to widget maker. And because you're a nice employer, and nice employers always finish last in California, by the way, but because you're a nice employer, you decided to keep their pay scale at what they were making as a supervisor or a lead. But it's out of whack with the other widget makers that you have employed. So my interpretation is you would not reasonably expect to pay a widget maker that you were hiring, even if they were experienced, at that higher rate that is based on different duties, supervisory duties. So one of the big questions that came out of this law is, do I have to post the wage scale based on what I am actually paying people? And my answer is, that's not what the law says. It says you must put the pay scale on what you would reasonably expect to pay for that position, not for a new hire, but just in general for people who regularly have those duties. Second requirement, and this requirement applies to all employers, not just employers with 15 or more employees. If an applicant requests the pay scale, you must provide it to them. So the law previously said you had to provide it to them after an interview. Now it doesn't matter whether they are interviewing or they're just walking in the door and asking for an application for employment. If they request to know what the pay scale is, you have to provide it to them. And of course, the law doesn't specify whether or not it is in writing or verbally. Probably best practice is do something in writing so you can demonstrate that you actually provided it to them. Now, you don't have to provide it for all positions. If someone comes in and says, I'm applying to be the widget maker, but I want to know what your president makes, you don't have to supply it to them, only for the position that they are applying for. And this also applies to employees. So if you have an employee who comes in and says, I want to know what the president makes, you don't have to provide it to them. But if they come in and say, I want to know what the pay scale is for my position, you have to provide it to them. And again, the number of employees that you have is irrelevant. So just to recap, if you've got more than 15 employees, then you have to put the pay scale on the posting. If you have less than 15 employees, you don't necessarily have to put it on the posting, but if an applicant or an employee requests it, you must provide it to them. So a couple of other things that are important to understand about this pay transparency law. They also included a record-keeping requirement, and this is a bit of a new record-keeping requirement. You must keep records of each employee's job title and wage rate history. So whether that's in your personnel file, on the jacket of the personnel file, whether that's a separate document that you include in the personnel file, hypothetically, you could have at least one document that shows job titles and one document that shows wage rates, being a summary of their pay stubs. But I always find that it's better to have something separate because you want to have it centrally located. You know you have it. If it ever comes up where the Department of Industrial Relations comes in and does an investigation and asks you where's the document, you don't have to scramble trying to collect a whole bunch of different documents from different locations. So you have to keep a record showing, yes, Carla was a widget maker when she was hired. She remained a widget maker until 2025, and then she was promoted to lead widget maker, and throughout all of that, this is how her wage rate changed. Whether that's a change due to minimum wage, whether that's a change due to merit increases or promotion increases, you need to have a record of that. And you have to keep those records for 3 years following termination. So this is something that I think a lot of employers struggle with. You know, the time comes when, and this happens in litigation too, some former employee says, I'm going to file a lawsuit, or the Department of Industrial Relations comes in and says, show us the records, and for whatever reason they got lost. So my advice there is keep a backup. If you've got paper files, keep an electronic backup, and vice versa, so that you don't have anything lost, because yeah, these things can come up 3 or 4 years later. So there's some open questions on these issues. One of the open questions that really isn't addressed in the law is who qualifies as an applicant. Do I have to fill out an application to be an applicant? Or can I just walk in off the street and say, I want to know your pay scale because I'm interested in applying? And what triggers the requirements to share the pay scale? And the reason why that's important is one of the worries we have as defense attorneys on the employment side is that people are going to be like these ADA litigants who just go around and find that you didn't paint the parking stall for handicapped people, disabled people, correctly, and they file an ADA lawsuit. And we could see the same thing here. People just go around to various employers, and when they don't get the pay scale given to them, claim, hey, I was an applicant and I'm going to sue for damages. So that's an open question, which is why if anybody comes in, even if they're not filling out an application, but they say they're an applicant, I would probably err on the side of caution and give them the pay scale. Is there a more precise definition of pay scale? As I said, I gave you my interpretation, that it's what you reasonably would pay and wouldn't necessarily include these unicorns, but the courts will ultimately weigh in on that, and or the Department of Industrial Relations will put out further guidance. Their initial guidance that they put out a little earlier this month didn't have a more precise definition. There's also an issue of whether or not, if you're an out-of-state employer, you have to follow this, even if you have one employee in California. In other words, the question is, if I have 50 employees in Florida and I have one employee in California, do I still have to post the pay scale on all of my job postings? And then same thing, if you're a California employer but you have a job posting outside of California, do I have to include it on there? And that is an open question. So what are the penalties for violations? They can be pretty severe. Number one, as I already mentioned, employees or applicants can file a private lawsuit for violations. The labor commissioner here in California can also assess penalties of between $100 to all the way to $10,000 for violations. However, here's some good news. There is a one free bite provision in this. You know how they always say that dogs have one free bite before they face some consequences. Well, the same thing for employers. The labor commissioner will not fine employers if they, because of a complaint or investigation, find that there's a posting that's missing the pay scale. If you're a repeat offender, however, these are the penalties. And there's a high potential here, I see, for PAGA claims. PAGA is the Private Attorney General's Act. It authorizes people to bring a lawsuit against an employer for penalties that could be collected by the labor commissioner. We are seeing an explosion of PAGA lawsuits here in California, and this is just one more element that plaintiffs' attorneys could look to sue on and try to extract settlements from employers. So it's definitely something that you want to take steps to be in compliance with, to do your best to make sure that those pay scales are on those job postings if the law applies to you, so you can avoid any of those penalties. Lastly, if you don't comply with the record keeping, there is a rebuttable presumption in favor of the employee if they bring some sort of wage claim. So in other words, if you can't produce the records and the employee says, hey, they were paying me $12 an hour when really my pay rate was $15, the presumption is going to be that 15 was the correct rate. So again, important to keep those records so you can prove that employees were paid accurately based on their pay scale. So, going to really quickly talk about large employers. Again, this applies to employers that have more than 100 employees. And if you have a labor contractor as well, a temporary agency where you've hired 100 or more employees, you have to file for that labor contractor. You must file a paid data report by the second Wednesday in May. So in this year, that's May 10th, 2023, and thereafter each year. The second Wednesday in May is kind of like April 15th. It's the deadline for filing this report every year. These paid data reports have to show data from the prior calendar year, and it has to show the number of employees in 10 categories by race, sex, and ethnicity. And then it has to show how many within those categories fall within the government pay bands for each job category or classification. And it also must show the median and mean hourly rate within each job classification by race, sex, and ethnicity. It's a very, very complicated report. So if you have less than 100 employees, be thankful that you don't have to go through this. I think most large employers are going to have to go outside to a contractor to be able to put this together because I think it's a pretty daunting task. You also have to show for each person the number of hours they worked in the year and the NAICS code on these reports. And there's penalties. Again, they can be pretty draconian, $100 per employee for the first offense and $200 for subsequent offenses. So again, if you don't have to comply with this, that's probably one less thing you have to worry about. If you do have to comply, my advice would be look to a resource to be able to help you. There are resources out there that help employers with the EEO-1 reports, and they are going to be transitioning to help employers comply with this new law. So let me talk real briefly in the time I have left about the COVID pay standard, Cal-OSHA standards. Sorry about that. If you recall, Cal-OSHA, which is the organization that governs workplace safety here in California, promulgated an emergency temporary standard back during the earlier part of the pandemic, and that was just an emergency standard. Recently in December, Cal-OSHA issued a COVID prevention non-emergency standard. So this should become effective sometime here in January. It has to be approved by a certain department up in Sacramento, but it will be effective through December 31st of 2024. So this is now a regular standard, not an emergency standard. Most of the regulations, the requirements that we've gotten used to as employers over the last couple of years remain in effect. So obvious ones, if somebody's positive, you need to require that they stay at home. You need to provide masks upon request. And if CDPH, California Department of Public Health, changes the guidelines with respect to masking indoors, then you're going to have to require people to mask up again. That hasn't happened as of yet, but if we have another surge later this year, CDPH could change those guidelines, and if they do, then employers have to comply with that. You also have to take additional prevention measures during outbreaks. If you have 3 or more people who come down with COVID within a 14-day period, then you've got to go through extra disinfection and cleaning and et cetera. So all of those measures are still in place, and you must give notices if an infected employee was in the workplace during the period that they were infectious. This has been a requirement that's been in place for a while. There's been a few tweaks to that, which I'll talk about, but all of those basic requirements are still in place, as well as the requirement that you offer free testing, COVID testing, if an employee has a close contact with an infected person at work. So what's changed with this new standard? A couple of things. Again, I'm going to go through these real briefly. There'll probably be some questions on it, but there's no longer a requirement to pay employees if they are excluded from work due to an infection at work. So in addition to the California supplemental paid sick leave, which expired as of December 31st of 2022, the Cal-OSHA standard required that if someone could show that they were infected from a workplace exposure, you would have to pay them for the duration that they were out of work. That has now been eliminated. So unless you are in City of Los Angeles, which will expire as of February 15th, or an unincorporated part of a Los Angeles County, or some other municipal or county jurisdiction that's still requiring COVID paid sick leave, you do not have to pay people if they can't come to work because of COVID exposure, whether that was out of work or inside work. So that was the biggest change to the COVID standard. Second change, under the old standard, the emergency standard, you had to have a standalone COVID prevention policy in writing that was distributed to employees. Now you must incorporate the COVID prevention policies into your regular injury, illness, and prevention program, which is a Cal-OSHA requirement. Every employer has to have an IIPP, and now your COVID protocols need to be in there. There's no screening required anymore. You do not have to take temperatures, ask people if they have a fever, anything like that. There is no obligation to offer free testing to infected employees. You only have to offer free testing to people who had close contact with an infected employee at work. Moving on, there's a change to the definition of close contact. This is the one I think is really difficult to understand, and I don't know why they did it. We all are used to the definition of a close contact as being within 6 feet of somebody for 15 minutes or more during their infection period, right? Well, they've changed it now, and it depends on the size of your workplace. If you have less than 400,000 cubic feet of airspace per floor in your workplace, it's a close contact if an infected employee was there for 15 minutes or more during a 24-hour period while they were infectious. So it's nothing to do with 6 feet, anything like that. If this is probably a location that has less than 400,000 cubic square feet. If someone comes in here is infected and they're here for 15 minutes or more, everybody who was here at the same time would be defined as a close contact. If you've got more than that, then it's the old standard of 6 feet. So if you've got a smaller workplace, which I think a lot of employers do, I can't remember the math. Somebody did the math for me, but it's basically, unless you're in a warehouse or a big plant or something like that, you're probably going under the standard of 400,000 square feet, which means you've got to give notice. So number one, the notice requirements are you've got to give notice to Cal-OSHA. You do not have any requirement anymore to give notice to the local health agency if you have a outbreak. And a major outbreak is when you have 20 or more people who come down with COVID within 14 days. So unless you hit that number, there's no obligation to report to Cal-OSHA, and there's no obligation to report to local health agencies. You no longer have to give individual notice to each employee that there was an infected person in the workplace. You could post a notice for 15 days in the location where you normally put up your employment posters to say that there was an exposure and the dates of that exposure and who to contact if employees want more information. So you don't have to email or hand everybody an individual notice anymore. You still, however, have to give individuals notice in the case of a close contact. That's where that close contact definition comes into play. So if you've got somebody who was in a conference room and they tell you 2 days later, hey, by the way, I started having symptoms on the date I was in the conference room and now I've tested positive, then you're going to have to give individual notices to everybody who was in that conference room. Okay, very briefly before I turn it over to Carla, I want to talk about this Camp versus Home Depot case. This is an issue of rounding of time. So Home Depot, in this case, was tracking time to the minute. They had a advanced Kronos payroll system that each employee would log in and log out, and it showed exactly at what time they started and at what time they ended to the minute. And They were also rounding to the nearest quarter hour. So in other words, if I clocked in at 7:55 a.m., it would round up to 8 a.m. So I would lose those 5 minutes. But if I clocked in at 8:05 a.m., it would round me back to 8, so I'd pick up those 5 minutes. So it was a neutral rounding policy that basically employees sometimes could benefit, sometimes they could lose out. And there was a class action lawsuit that was filed, and the trial court in the case dismissed it because they said, look, there's this case called See's Candy. We all know See's Candy, right? I'm still getting rid of the stuff I got from Christmas. And the See's Candy case says neutral rounding policies are fine. So the trial court said, yeah, no harm, no foul. It went both ways, so therefore this was a legal rounding policy. The Court of Appeal here in California reversed that decision. And the Court of Appeal said, neutral rounding is not allowed where time can be tracked to the minute. So employees should be paid whatever hours they worked. If they clocked in at 7:55, they should be paid starting at 7:55. If they clocked in at 8:05, they should be paid starting at 8:05. And Home Depot, we don't think you should have had this rounding policy. Now, the court said this is limited to these facts where there was an advanced timekeeping system that tracked hours worked to the minute. And if the timekeeping system didn't necessarily track hours to the minute, the court said our analysis would not necessarily be applicable. And it does not require, this decision does not require that you adopt some sort of advanced, technologically sufficient system that tracks hours to the minute. The court just said, under these facts, we think See's Candy doesn't apply and rounding should not happen. So the bottom line is if you're rounding, you should really reconsider that practice. And my advice would be probably discontinue it. Pay people to the minute if you can. Because I think this Camp decision, if it goes up to the California Supreme Court, is probably going to lead to the overruling of See's Candy, and that can create a lot of potential liability for employers going back 4 years. So my advice would be, if you're rounding, stop, pay people based on when they clock in and when they clock out. Because I can see this coming down the road in 2023, and the sooner we take steps to be in compliance, the better off we are. Real quick, I'm going to turn it over to Carla. Minimum wages. So we've got the state now requiring $15.50 as the minimum wage for all employers. Prior to this year, there was a distinction between if you had 25 employees versus more than 25 employees, but now the minimum wage is the same for everybody. It's $15.50. In LA, there's a special minimum wage that's $16.04. An unincorporated LA County, it's $15.96. Those go up in July every year, so there's a different schedule for minimum wages. If you're in the city limits or you're in an unincorporated area, check what your local county or city is doing, because there's more and more cities and counties that have minimum wage ordinances and sick leave ordinances that are different from what California requires. And just to make sure that everybody's aware that the minimum salary for exempt status, in other words, if you're going to pay somebody on a salaried basis, not pay them overtime, you're going to consider them exempt, is now $64,480. So you can't have a marketing manager, for instance, making $55,000 a year and pay them on an exempt basis. They must be paid hourly. And the highly paid computer exemption went up to $112,000 and change. Okay, so I'm going to turn it now over to Carla, who is going to talk about some of these new laws that affect leaves and bereavement leave and care for designated persons, and a little bit about some important things to keep in mind as religious employers.
Great. Thank you.
You have the calm.
Great. Hello, everyone. So the first thing we'll talk about is AB 1041, which is the leave to care for designated persons. And this is changing CFRA. So currently, CFRA is for a family member. The change here is that, and CFRA is leave that allows you to, an employee to be off for up to 12 weeks in a rolling year to care for either to be sick themselves or to care for a family member. This change will be that it's for any person who is related by blood or their association is equivalent to that of a blood relative. So, and the employee is the person that gets to define that relationship. They can identify that relationship. It's not like at the beginning of each year everyone has to make a list of people on their list. They can identify the relationship as that, close as a blood relationship or a family relationship at the time they request the leave. So if they come in and request leave and it's, this person that they consider a family, then we would need to honor that CFRA leave. You can limit the number of designated people to one person per 12 months. So keep that in mind that, if a person has, this week I need 2 weeks off for this, and then next week I have another person that is like family to me, within that 12-month period, you would be able to limit it to that one person if you desired. Keep in mind that if you went ahead and let them designate another one, then you would need to be making that your practice for how you administered that leave. Kind of hand in hand with this is paid leave for designated persons. So California sick leave already allows you to either be sick yourself or care for a sick family member. This would also allow this designated person to be added to the definition of what a family member is. There's no requirement for a relationship by blood or a close relationship. That it is just if the employee says this is a close relationship, then they can take their sick leave, their California sick leave, for that reason. So, and with California sick leave, they don't have to prove this relationship. So, be careful about not going too far in asking them to prove their relationship or to prove the illness or to, we want to be, let them designate their person. Again, this can be identified when they ask for the sick leave. There's no pre-existing list that they're allowed to say, okay, now this person was on my pre-existing list. And again, we can limit that to one person designated per 12-month period. So we'll just need to be aware of that as we handle our leaves, both our sick leave and our CFR leave. The next thing is unpaid bereavement leave. So this is a new, was in effect January 1st, and there are, the state is now requiring that employers offer 5 days in the event of a family member. This leave is not paid leave. So the deal will be, if you already have a bereavement leave, which many times is 3 days of paid sick leave, you'll have to look at your practice and your policies and how you're going to incorporate this 5-day unpaid leave into your existing policy. The employee does need to be employed for at least 30 days before they're eligible for the leave. The family member definition is the same as CFRA, so they can, claim a close as family or blood relation, and it can be taken non-consecutively within 3 months of the death. So if they need a day or two off right away, and then maybe something later within 3 months for a memorial, or they need to split that up a little bit, they are allowed to do that. Keep in mind it's unpaid leave. They also can use other leave that they may have, other PTO that they may have on the books or accrued during this time. So they can, if they want to take some vacation pay, they can take some of that while they're on this leave, on this unpaid bereavement leave. This is kind of now, how do we work that into, we already have 3 days paid off, how do we now work that into what we have? So if it is currently offered, you can count it against the 5. This doesn't have to be in addition to what you already have. You can count those, say you have 3 days, just because that's kind of a common time. You can incorporate that into your 3 days. Some people may want to say, okay, we'll just make it 5 days paid. Some people may want to, somehow go back to just unpaid, but it's 5 days. And it's not just to go to a memorial service. It would be, the bereavement is not defined what they're doing while they're off. It's just the death defines the bereavement leave, not what they're doing while they're on there. You can require a death certificate or some other, maybe the prayer card or something that they get at a memorial service. If you do want to require documentation of the death, you are allowed to do so. You don't have to, but you can if you do. If you do, make sure you do it for everybody. And, death certificate, written proof, an obituary in a newspaper. Just, if you're going to do it for everybody, for sure. It would be an unlawful employment practice to deny this leave. So we don't want to deny the leave. We want to give people their leave and document what you're doing. We want to be fair and allow this leave to be taken. Off-duty cannabis use. This law is actually not in effect till January 1st of 2024. But we can start thinking a little bit about it now, but we won't talk too much about it now. This does, this AB 2188 prohibits the firing or refusing to hire employees for off-duty cannabis use. It is a protected classification under FEHA. So because of that, you can still prohibit possession or use at the work site or being under influence at the during work. This is not applicable, though, to a religious organization or a nonprofit religious corporation, because it is a part of FEHA, and we are not. We would under the religious exemption, we would not be subject to that particular ordinance and law. So even though that's out in the future and there will be a lot of talk about it, right now, for religious organizations or nonprofit churches, we would not be subject to that law. Okay. These are for some specifics. This isn't all new law, but just some specific things that come up for religious employers. AB 506. So this was a law all the way, it's not a new law anymore, but it's kind of a continually evolving law. And this is the law that requires live scan background checks for employees and volunteers that work with youth. So we've always had a standard of care when it comes to protecting people from child abuse. And there's been a background component that we might do, but now the background component is a will do, and it is a live scan. So in California, the live scan background check will be required. Now, you do have to be registered with the DOJ and have your OIR number in order to be a part of that program. And because there was a backlog and it does take time to get set up with that if you're not already, that requirement has been delayed until January 1st of 2024 if you were not already doing it. If you are already doing live scans, then the requirement is in place. The law AB 506 also requires training on the prevention of child abuse and reporting. You have to have your policies on reporting in place, and there is a requirement to have 2 mandated reporters present with children. The spirit of this law and the intent of the law seems to be to codify the idea that 2 adults need to be with a child, that no one is with a child alone. And so we believe that the spirit of the law is that this 2 adult to 1 child rule, and the training that you will be giving people is what a mandated reporter would do. And so we believe that that is the spirit of the law, is it's really codifying that 2 adult. There are some carve-outs in some to this law for one-on-one mentoring, like Big Sisters, Big Brother programs, and there's another set of regulations that go along with that, but that is being addressed as this law evolves. We have not seen issues with renewals with your insurance carrier over compliance with AB 506. Most carriers already had underwriting requirements that were more than, or at least equal to, what AB 506 requires. And so we're not having any problems with non-renewals from the carriers on AB 506. So it's just making sure that you have your training in place, that you are getting your DOJ OIR number, and that you're getting set up for live scan fingerprinting. We still, Ministry Safe is a go-to partner when it comes to child safety, and especially AB 506. Their training is excellent, and we would suggest anybody just embrace their whole system of child safety, and that will meet these requirements as well. We also suggest that even when you start your live scan background checks, that you continue to do your federal criminal background checks that you're already doing. Each one of those things will miss something that the other one catches. And so we want to make sure that we're at least considering, and we are recommending, that you do both of those things. The other thing that a lot of people are asking about right now is, what about those required law posters? And everyone's getting these scary-looking things in the mail or emails that you're out of compliance and all these giant fines. And it is true that there are required labor posters. What's also true is that religious employers are not subject to every law that some of those giant composite posters, which are very convenient, have in them. And so just want you to be careful if you're ordering, one of those composite posters from, Chamber of Commerce or something like that, that you really go over that poster and read each notice in there and make sure that your organization, number one, is subject to that, to whatever that poster is talking about, but also that your organization is doing that. So, if it's an EEOC thing about discrimination that's administered by FEHA, you don't have to post that if you're a religious employer. Or you may want to post it with, an extra notice amending that, we are not, while we're going to follow this is not, it won't be the whole thing. We will maybe, discriminate on the basis of religion, things like that. So you just want to be careful that whatever's in that posting, that it's not just up there, and that your organization is really doing that. Another example would be unemployment benefits. If you have a poster about unemployment benefits up in your break room and you don't participate in unemployment, that would be a conflict. And so there are some posters that are applied to everybody. And, there are some Department of Labor posters, so we really want to just really be careful to go through and either amend a poster or not post it if it doesn't apply to your organization. And it will probably mean that you won't be able to use those giant composite posters anymore. The other thing to, sorry, I talked without doing the deal. The other thing to be careful of, if you do have remote workers, they still get postings too. And so you would post the same things. It needs to be in a very accessible place. So if you have an intranet, that would be a great place to post those, or even if you have a Dropbox or something that you can set up that people know where they can go to get those postings. Things like this can also be handled in your employee handbook. And so we want to make sure that we aren't just sticking, a template of a handbook in our employee handbooks that, say we won't discriminate or, applies to something that actually, as a religious employer, we're not subject to. Okay.
All right. So we did have a lot of questions come in, so let's jump right into the Q&A. We did get a couple questions related to the pay transparency portion of the presentation, specifically the record keeping. Is the record keeping requirement for job titles and pay rates retroactive?
So that's a good question. So it's retroactive to the extent that the law requires you to keep them for 3 years after somebody's been terminated. So if you have people that have been terminated in the past 3 years, I would say the safe thing to do is make sure that you keep those records for at least 3 years following the termination. It's not retroactive in that they're not going to go back and say, hey, you weren't keeping the records of Julie, who's been with you for 15 years, back in 2017.
Okay.
But I think for terminated employees, that would be the safest thing to do. Obviously, with current employees, you don't have those records, but you would want to start keeping them now.
Okay, great. Next question says, does the record keeping apply to employers with less than 15 employees?
Yes.
Okay.
Yes. So the 15 employee threshold is the threshold they put in for the requirement on the job postings. Everything else, they said, nope, we're going to apply that to everybody.
Okay.
Good question.
Okay, next question. This is for pay. So for positions where there's not necessarily a low to high schedule, say for support staff, but they have a lowest wage but not a highest one, can they just post, for example, starting at 18 an hour plus?
Okay, so good question. The frequently asked questions that were published by the Department of Industrial Relations say that if you pay a uniform amount for a particular position, let's say you've got support staff and all the support staff make $18 an hour, then you would post $18 an hour. Okay, but if you've got a range of people that you are paying, the starting wage is $18, but I've got Julie who's been with me for 15 years, right? So Julie gets 22. What you would reasonably expect to pay for that position is probably that range of 18 to 22. So I don't think you would be in compliance if you have a range that you would expect to pay for that position. Not when they're hired, but in general, if you've got a range, then you can't just put 18 plus.
Got it.
But if everybody's making the same rate, all widget makers make $20 an hour. It doesn't matter, how many years you've been widget maker or whatever, then you can put that 20. The other thing that I didn't mention, because I wanted to get through the slides with the time we had, if you do have those situations like you just described where, hey, we've got this entry-level administrative position and most everybody makes $18 an hour, but I've got Julie who, no, she's been with me 40 years, right? She looks amazing. That's 40 years employee, just hasn't aged a bit. And we pay her $25 an hour because she's been there so long, okay? And you don't want to post a range of 18 to 25 because from an employee relations perspective, you don't want people going, hey, when am I going to get 25, right? Create a different classification. Because remember, you only have to post the pay scale for the classification you're advertising for. So if you say, okay, Julie is now the senior administrative assistant, right? Now she's a different classification. You don't have to post her hourly wage or salary as part of what you would reasonably expect to pay for the job. So that's a way to avoid a problem from an employee relations standpoint and from a compliance standpoint when you have these unicorn employees who are basically outside what the reasonable pay scale is.
Okay. Okay, you may have answered this a little bit, but do we need to create wage history for existing employees, or does this just apply to new employees going forward?
You need to create it for both your existing employees and your new employees. So at least starting January 1st, 2023, you need to have a record for your existing employees and anybody you hire after that of what their position is, what their wage is, and any time that position or wage changes.
Okay. Okay, so this one is about the minimum wage. With some employees working from home, is the minimum wage based on where they work at home or where the organization's business address is?
Oh, that's a great question. I love that question. And the answer is it's where they work. So for instance, the City of Los Angeles minimum wage ordinance says that if you spend on average more than 2 hours a day working in the city limits, then the minimum wage ordinance applies to you. So, which of course creates huge compliance issues if you've got drivers, for instance, who are transiting through a city or county. So if that employee works at their home in the City of Los Angeles, then they are going to be falling under the city ordinance.
Okay.
Good question, though. I like it.
All right. Okay, so another pay question. We have paper timesheets, and when I onboard employees, I instruct them to write down their time however they want, as long as it's their accurate times. I say we generally round to the nearest 5 minutes, but if I see exact minutes on the timesheets, I will calculate to exact minutes. Is this permissible?
Okay, so the holding in Camp versus Home Depot would not prohibit your rounding practice there because you do not have a type of advanced timekeeping system that records work time to the nearest minute. People can basically write down what they write down. So Camp doesn't apply. I would be concerned, however, that the way the trend is going, any rounding practice is going to end up being found to be not acceptable. And the problem for employers is some of these laws, we talked about retroactivity, a lot of times in wage and hour, the courts say, yeah, this is retroactive. So even though you were going under, what you thought was the law under See's Candy, in this class action lawsuit or this PAGA lawsuit, they can go back 4 years for class action, 1 year for PAGA, and you're like, well, wait a minute, why are you applying this to us retroactively? And the court's answer is, well, it was always this rule, we just had to get to the decision, so it was always like this. So I think in that circumstance, I would look to discontinue that practice and just pay people based on what they wrote down.
Okay.
Yes, I agree.
Yeah.
Okay. Okay, next question. Is the salary of $64,480 for all employers, even churches with small staff? And then this is a part two. Also, the unpaid leave, AB 1949, is that for all? We are a small church with 5 employees.
You want to take it? No?
Take
No?
it.
Okay. The exempt employee, the exemptions apply. In order to be classified as exempt, there's, like agriculture, I think there may be some exceptions, but exempt status is, now, we have to distinguish between people who are ministers, right, who are actually, in a vocation, versus people who are not ministers. They're not the, ordained or whatever the case may be, but they may be acting in some type of ministerial capacity, like Sunday school teachers or preschool teachers or music ministers, things of that nature. The ministerial exception under FEHA, which is the anti-discrimination laws, applies to everyone that is working in that ministerial capacity. The exemption for wages only applies to the ordained minister folks. Okay? So ordained minister, no, you don't have to pay $64,000 because they are a separate exemption, right? But if you want to have a director at your preschool and you want to classify him or her as exempt, then you're going to have to meet that exempt standard. Second question was bereavement leave, right?
Yeah, the unpaid leave, is that for all? We are a small church with 5 employees.
So you have 5 employees, you qualify under CFRA, and it's the same standard for bereavement leave. So 5 employees or more, the unpaid bereavement leave rules apply to you.
Okay, another question on bereavement. If the employee has several deaths in 1 year, is the 5 days total allowed?
It's per death, isn't it?
It is
Per
per death.
Okay.
Yeah. So
Yeah, fortunately or unfortunately.
yeah,
Per death.
they could have multiple. They could have multiple 5-day unpaid leaves during the year.
And that actually wouldn't be that uncommon to have more than one death.
Sure. Sure.
It seems like often
Yeah.
a family will experience more than one death in a year.
Yep.
Okay.
Now they can choose to use their sick leave, and you could, if I remember correctly, require them to use vacation.
Okay.
I believe so, but for sure you can't require them to use sick leave.
Okay. Someone asked, what is FEHA? Want to explain that?
So FEHA is the Fair Employment and Housing Act. So it is the basic anti-discrimination, anti-harassment statute in California. So just a little background. So FEHA says that there are certain protected classifications, right? And those range from race to age to disability to religious practice to sexual orientation, pregnancy. They're adding them every year. As a matter of fact, one we didn't talk about, there was a protected classification added this year for reproductive decision making, which means that if an employee makes a decision regarding reproduction, like using birth control or having an abortion or whatever, that is a protected classification under FEHA. So what Carla was talking about with these posters is that religious organizations aren't subject to the anti-discrimination statutes under FEHA. And that's, true religious organizations or something connected to or sponsored with a religious organization like a school. Most employers have to put something in their handbook, and it has to be on their posters, that says, we don't discriminate on the basis of age, race, sex, religion. Well, wait a minute. We're a religious organization. We're not going to hire people who are of a different religion or no religion to teach the religious precepts of our faith. And so that's why the FEHA carve-out applies to religious organizations. Same thing with things like sexual orientation or transgender. You don't have to put that in your handbook, and that's what Carla was referring to. You don't want to put that composite poster up because it says we will not discriminate on the basis of all of these things, and if you put up the poster, you at least open the door to someone saying this was the policy of that organization, and your organization is saying, whoa, we do have some practices where we require certain tenets of faith to people who come to work for us. So that's kind of the backstory on that.
Okay, so with the topic on the labor law posters, can we simply cross out the notices on large labor posters that do not apply to us?
Yeah,
Yeah,
Okay.
yeah, that would be one solution.
it will draw attention to it, but I don't know if that's your intention. Just be careful, just know that it would draw attention to it, but yes, you can do that.
I mean, I think the other solution is you can always, all of the posters, the ones that are required, like minimum wage, for instance, you can print them out from the agency that governs, in this case, the Department of Labor Standards Enforcement, and then you just put up
Right.
that single poster for each of the requirements that actually apply to you as an employer, and then you just don't put up the FEHA poster.
Yeah, that's what I would do. I would,
Okay. Yeah, we had a couple questions asking if there's a specific recommendation for a religious organization for labor law posters.
there's not, and the reason is because even every religious organization will have differences between each other. There's not a blanket. One religious organization will want the unemployment part of it. One religious organization doesn't, they don't want to take advantage of an exemption, a religious exemption. Perhaps, sexual orientation isn't a tenet of their faith. So we don't want to assume that even every religious organization would be the same. I think the best thing would be to go to the requiring agencies, download their required posters, and just, make your own kind of bulletin board.
Yeah.
Okay. Okay, going back to salary. All of our case managers are making $46K annually as salaried employees. When are we required to take them off salaried status?
Okay, so you can, so the distinction in the law is exempt, non-exempt, right? If you're going to treat people as exempt, meaning that you don't pay them overtime, they're not entitled to an unpaid meal period, they're not entitled to paid rest breaks. That's what exempt means, okay? If you're going to treat them as exempt, then they have to make that minimum salary. So you could not have your case managers as exempt on that salary. Now, you can still have them on a salary and treat them as non-exempt. That is a legal category under California law. But if you're going to do that, you need to make sure that they're tracking their hours. See, exempt employees don't track their hours, right? Because it doesn't matter how many hours you work, you're going to get paid the same thing. Non-exempt employees, you need to track their hours, and if they go over 8 in a workday or over 40 in a work week, then you need to pay them overtime based on their salary, and you need to make sure that they're clocking out for their meal period and that they're taking their 10-minute rest breaks. But you can still pay them a salary. And if they don't work overtime, I have a lot of employers that still do that. It's just you got to make sure you're tracking their hours.
You do, yes. Just be very aware that none of the timekeeping requirements go away.
Okay. So how do we handle recording for non-exempt salaried employees who attend camp, for example, or who have worked more than 8 hours?
So my answer would be you would want something in writing from the employee verifying that these are the hours that they worked. Okay? So for instance, they go to camp and they're working, well, I've been to camp.
20 hours.
20 hours, yeah. They don't
Depending
have,
on what goes on.
They don't have to be paid when they're sleeping.
Yes.
But
But sometimes they don't get to sleep much.
you don't get to sleep much. So when they're on duty, they need to write down, started at 6 a.m., took my lunch break from, 10:30 to 11, right, before the end of the 5th hour of work, worked from 11 to, 8 p.m. And then you pay them based on that, and then they would be paid overtime for the time that they worked over 8.
Okay. Does the minimum wages apply to ministers who has housing allowance?
Right. So ordained ministers, right, are exempt from the minimum wage and exemptions and all the other stuff. So, you could have, hypothetically, a minister who doesn't make anything.
Right.
Right.
They're like outside salespeople. Same concept. Outside salespeople are completely exempt, meaning that if I'm an outside salesperson, I'm knocking on doors trying to get sales, I could get paid 0
Yeah.
because I only eat what I kill.
Right. So do pay scale reporting requirements apply to independent contractor positions?
So the answer is no, but which is a good lawyer answer. Look, if it's an independent contractor, there shouldn't be a pay scale, right? An independent contractor is somebody who is performing a service for your business and you are paying them for that service, right? So the but here is that if you've got people that you're calling independent contractors and they're not real independent contractors, and there's, I can do a whole webinar on that, okay? Just be careful because if you're thinking about pay scales for them, then my guess is they're not independent contractors.
It's likely that they need a reclassification.
Yeah.
Okay. All right, so this will be our last question. We did actually get a couple of these about the bereavement leave. Does it need to be local or is it just California? Like, if the death is like out of state, does it apply to that?
Well, it applies to where the employee works, not where the death was.
Okay.
So if it's a California employee, then they are entitled to that unpaid leave.
The aunt in Texas dies.
Yeah,
They want to go to Texas for the funeral. Yeah, you got to grant them the leave.
yeah.
Okay.
Yep.
All right, so I think we could do one more. Let me see. Is there an exemption for interns regarding salary and exempt employees?
So there's two types of interns, okay? One intern is working for an organization for educational credit, and they are getting credit from an educational institution for that internship. If that is the case, then the regulations that we're talking about in terms of wages wouldn't necessarily apply, okay? And that type of intern isn't performing the same work as employees. They are mentoring, they're shadowing, they're not coming in and they've got a list of tasks they have to do every day, right? That type of intern is let's just call it exempt. But just calling somebody an intern doesn't make them exempt.
Right.
If you're saying, well, I'm going to give you an internship, you're not getting any college credit for it, that's a W-2 employee who needs to be paid minimum wage.
Okay. And same for volunteers, because someone asked, can non-exempt employees volunteer for events?
Well, okay, so again, another great topic. Volunteers are people who are performing work with no expectation of compensation for that work, okay? The danger here is if you have people who are employees and they're volunteering, it is very easy for somebody to come back and say, well, no, I thought I had to, and they put me to work and I didn't get paid for it. So in any volunteer situation, my recommendation is you have something in writing from that volunteer saying, I am performing this work or these services without any expectation of being compensated for it. I understand I'm not going to get paid. I'm doing this strictly on a voluntary basis. Sign it, notarize it, make them, prick their finger and, put blood on it. I mean, get something that's really, really, because I've had too many occasions where people have come back because something goes wrong in the relationship and they say, well, I volunteered 300 hours last year and I never got paid. Pay me.
Right.
Right.
So just be careful with that.
Okay.
Again, if it's not in writing, it didn't happen.
Yeah.
Right.
So make sure you have that in writing so you can prove that employee was not expecting any compensation.
I usually say as a best practice for that, it's good to not have them work in the same ministry that they get paid to work in, if possible, and also not doing the same work. So if a person's the administrative assistant in a department, they can't do the admin work for every other ministry as a volunteer.
Right.
So, I try to draw some lines of, because on the other hand, if maybe the administrative assistant has always volunteered at BBS and wants to continue to do so, I don't want to say no to that either.
Right.
I want to say, yes, of course we want you to volunteer at BBS, but just don't have her doing only administrative tasks there.
Okay. Perfect. All right. Well, that'll conclude our presentation for today. Thanks again, everybody, for joining us. We did have a lot of questions come in, so if we didn't get to your question, we will do our best to have Eric and Carla answer those offline for us. And thank you, Carla and Eric, for your time today. And
Welcome.
we will see you at the next webinar.
Thanks,
Bye,
everyone.
everybody.
Thank you.